should.
Okay, perfect. Well, thank you everybody for registering and coming tonight. We're very excited to have you all. We have a full house tonight, which is amazing. So first we'll start with the land acknowledgement. Want to slide? So we would like to acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. So thank you everybody for coming here and being on this land. And this is a land that we get to work, play, and live on. Okay, next slide. Okay, so for anybody who is not familiar with Amici Curie, so it's Amici Curie, Friends of Court, or as we call it, AC. So throughout the program, you'll probably just hear us say the words AC. So AC is a nonprofit organization. It began in 2011 with its first legal forms workshop being held at the offices of the Access Justice Center that was just behind the provincial courthouse. Sorry guys, I have notes here and I keep moving back and forth, so just bear with me. So basically with AC, so we started out by helping self-litigants such as yourself with their court documents. Fast forward to 2022, we began to expand our services by holding informational sessions for AC clients to help them better understand legal procedures. This started with, if any of you have seen it, our YouTube series called Everyday Law Series, which has now grown into other types of programs that you see today, which you are a part of today, which is the Amici Curie Family Law School for Self-Litigants. To our knowledge, this is going to be the first type of school program of its kind in BC. It was important to start this program as our AC board learned that approximately 45% of our clients are family law litigants. Okay, next slide.
So we just wanted to acknowledge some of the people that have helped us with our family law school. They would definitely not be possible without their contributions. So Kylie Wong, she's one of the lawyers that assisted with this. Don Batista, he is our executive director with the AC Friends of Court. Dana Cornwall is a project manager, and Andrew Pillar is a director for the NSRLP Society. And we would just like to thank and acknowledge the fact that we adapted some of these resources from the Justice Education Society, National Self-Represented Litigants Project, and Legal Aid BC.
Oops, had myself on mute there. So now to introduce us, your chairs for this program. So my name is Jennifer B. I'm a paralegal and legal coach. I have been doing family law for 9.5 years now. And I've been a volunteer for Amici Curie since 2016.
My name is Rachel H. I am a paralegal, designated paralegal, and I've been working in the area of family law for about 7.5 years. And I've been working with Amici Curie. I just started this year in 2023.
Hi everyone, my name is Emily. I am in my final year of law school, and I've been with AC Friends of Court for I think 1.5 years now. Yeah.
So we just want to remind everybody, if you've been a part of the family law legal forms workshops or just in general, we do not provide legal advice. These are just sessions provided about legal information only. Okay. So a reminder that all of our sessions are going to be recorded, and if anybody misses a session, we are able to email a copy of the recording to the registrant. If you haven't already done so, I know we have quite a few of yours, but just make sure that you send in your participation agreements if you haven't already. If you want to just double check in your spam folder, sometimes the emails go there if you haven't seen it. Otherwise, definitely send us an email and we can resend it to you. Everybody already has muted, but just a reminder to keep it off and make sure your video is off as well. For privacy, we don't want anybody to have their name recorded. We will have a question and answer session at the end, so feel free to put any of your questions in our chat box and we will get around to answering those at the end. And just reminder to keep respectful when communicating with others in the chat box. And any questions that you have, just email us at this email address on the screen. That's the info@litigantschoolbc.com.
Yeah, like Rachel was saying, just please make sure that throughout today's presentation and also throughout our entire 11 weeks of sessions that you're respecting the speakers who are volunteering their time, as well as AC volunteers and staff and the other registrants that are participating in this program. And that any kind of abusive or harassing language or behavior is not something that we're able to tolerate as an organization. So anyone who engages in that kind of behavior will unfortunately have to be removed from the program.
This mute button is getting the best of me. So today's objectives is to clarify your expectations of what your self-represented litigant or SRL journey will be like. Understand the difference between BC Provincial Court, BC Supreme Court, BC Court of Appeals, and the Supreme Court of Canada. So all of our levels of court. Understand the relationship between all the family law statutes. Understand that many cases settle and that yours may too. Identify dispute resolution mechanisms outside of the courtroom. Locate helpful free and low-cost information and resources to help you move your case forward.
So similar to what Jennifer was just talking about, our outline for tonight, we're going to go through the self-litigant experience, kind of what your journey may look like as a self-represented litigant, types of what court we have in BC, and again, the important family law statutes or the important law that we have here in BC, solutions that are offered outside of court for people in a family law matter, and then helpful information and resources and links. And then again, we're going to have our question and answer session at the end.
All right, so I guess I'm going to start us off with a little bit about your journey as a self-represented litigant. So as you might know from our earlier slides, AC Friends of Court works almost only with self-represented litigants. And so unfortunately, none of us have had this experience ourselves, or I guess fortunately. So we're unable to really speak from our own experience about what that might be like. But from our work with self-litigants through our experiences, we're able to say that a lot of self-litigants come to us with looking for help with navigating through the court system, like choosing which court to go to, as well as, filing documents and paperwork. How do I complete documents? Which documents should I be completing? When should I be handing those in? And how do I write in, I think a lot of people might think of it as legalese, or like kind of a separate language almost that's only used in law. A lot of people come to us very stressed about the situation or about appearing in court. And then, of course, appearing in court can be very stressful, not only for self-litigants, but also for lawyers. It's very unpredictable, and it can feel very overwhelming. So those are some of the things that we've heard, and we're hoping that through this family law school that we're able to help out with some of those experiences.
Okay. So setting expectations. So it's clarifying your expectations of what your SRL journey might look like. So during your legal journey, you need to manage your expectations throughout this process. Most legal cases, no matter the type, are ever straightforward or easy. Going into a court case is unpredictable. Some of the legal procedures or policies can be overwhelming and frustrating at times. Because you're basically entering into a bureaucratic process, there will always be bumps in the road. Sometimes there will be delays, whether it be with the registry, communicating with your former spouse, or even their lawyer, if they have one, or having your matter heard in court. This is not to discourage any of you from either starting a court action, or if you already have one, to discourage you from continuing your court case. But it's just to keep into the back of your mind that these things do happen. Justice isn't always swift, but there are ways to bring it to an end. However, patience is needed in this process. While you are on your SRL journey, you also need to have ways to help cope during a process that can be daunting, triggering, and discouraging at times. Some tips and examples to help you decompress, if you haven't utilized these yet, is number one, having a support group or a designated person that can support you during this difficult process. Do not go through this journey alone. Avoid it if you can. Find affordable self-care means, and that can be anything. It can be as simple as going for a walk and just enjoying the fresh air, having a bubble bath, which might sound cheesy, but sometimes playing with bubbles helps distract you. Meditation or meditation music. If you have access to iTunes or Spotify, you can always find a meditation playlist. And even journaling, as cheesy as that sounds, sometimes just writing out your feelings. I do it sometimes too when I'm frustrated, and it's just fun to just vent it all out. Finding and using community resources. So if you live near community centers, sometimes they'll have resources for, low scale, affordable counseling, group sessions, just anything to kind of get you out of the community and just get you out of, your own head. And finding affordable legal resources, such as this course, to help you navigate your family law case. My co-chair, Rachel, will provide you with more resources later in the session. Finally, know when to end a case and move forward for yourself and your loved ones. It can be hard to move on when you have been consumed in something that can take up your time and energy. However, it is very important that when this journey ends, and it will, that you take the time to practice not dwelling on what happened or try to resurrect small details. Sometimes you need to ask yourself, is it worth bringing it up?
All right, so now we're just going to go over the types of court that you'll see in BC. So in BC, there are 3 different levels of court before you get to the Supreme Court of Canada. The first level of court is provincial court, and that's called the Provincial Court of British Columbia, or sometimes you'll see it abbreviated as BCPC. After that, you have Provincial Superior Court. In BC, we call this the Supreme Court of British Columbia, and it's abbreviated as BCSC. But in other provinces, it might have a different name. If you're from Alberta, for example, you might be familiar with the term Court of King's Bench or Court of Queen's Bench. Those are the same thing as the Supreme Court of British Columbia, just the Alberta version. And then after that, you get the Provincial Court of Appeal. In British Columbia, it's the Court of Appeal of British Columbia. They also abbreviate it as BCCA. And then after that, you get to the Supreme Court of Canada, which is abbreviated as SCC. And so I know abbreviations generally aren't used, when you're talking about something, but you might come across these in legal documents or forms. So I thought it would be helpful to put those in. So in British Columbia, all 3 levels of court, so that includes the Provincial Court, the Supreme Court of BC, and the Court of Appeal will hear family law cases. But most family law cases will be seen in Provincial Court or BC Supreme Court. The Court of Appeal only hears cases that have already been decided on by other courts. So you can't go directly to the Court of Appeal for any kind of case. Yeah, so now I'm just going to cover, should I go to provincial court or should I go to BC Supreme Court? And a lot of times this can be confusing because they both hear family law cases and they actually will make a lot of the same decisions on the same types of subjects. So it might be something you want to think about going forward if you plan on continuing or starting a family law case. So the first thing I wanted to cover is the types of orders. So when you're deciding whether you should go to provincial court or Supreme Court, the first thing you want to think about is, well, what am I looking for the court to do? What do I want the court to give me at the end of this? So if you'll see on the left-hand side, provincial and Supreme Court will make a lot of the same kinds of decisions in the same types of subject areas. But then there's, on the right-hand side, two things that can only be done in the Supreme Court of BC. So if you're looking for a divorce in BC, you have to go to BC Supreme Court. And if you are looking to have your property or debt divided between you and your ex, you also have to go to Supreme Court. Anything else can be done in provincial or Supreme Court. And you might just want to consider a few other factors that I'll go through later. So spousal support, child support, guardianship, so who's the guardian of your child, parenting time, so how much time you spend with your child, as well as parenting responsibilities, which used to actually be called custody. That's generally a more familiar term. Relocation, so if you intend to move with your child somewhere else, or if your ex takes your child and moves with them somewhere else, you can go to court and ask them for permission to do that, or you can ask your ex to bring your child back, as well as protection orders in a family violence context. So if you're experiencing violence, you can get a protection order that allows the police to protect you in those circumstances, or conduct orders, which are orders that make sure that somebody behaves well in court, for example, or outside of court. A really popular example of a conduct order is an order that makes sure both parents avoid speaking negatively to the children about the other parent. So that's a very common one, or that the parties need to communicate only through text messages and email instead of in person. So that's a conduct order. All right, so in provincial court, I just want to bring this to your attention. Today, we're actually, throughout this 11-week course, we're only going to be covering Supreme Court, not BC Provincial Court. But I just want to bring this to your attention that the provincial court does have special processes for two different things. The first thing is protection orders. So if you are experiencing family violence, the best way to get a protection order, generally speaking, is to go to provincial court. They have a special process for it. They're able to get you that protection order much faster than in Supreme Court, and it's also free. The other thing is priority parenting matters. And as you see in this list here, that includes time-sensitive or emergency medical treatment, passports, licenses, permits, or benefits for your child, any kind of application about traveling with a child or a child's activities that will take place somewhere outside of where you normally live. And then removing a child from a specific area in BC, like I was saying, if you plan to move with your child to a different province, for example, you would want to go make an application for permission to do that, or returning a child. So if somebody else takes your child outside of BC and moves them without your permission, you can also make an application for that. So those are called priority parenting matters, and provincial court in BC has a streamlined process for that is free and much faster, generally speaking, than going to Supreme Court. Again, we won't be covering this, but Rachel will talk about some of the other resources available at the end of today's presentation. And many of those resources will be able to provide you with information or help with either of these things. So the last thing that you want to consider, so if you're going to Supreme Court versus provincial court, there are a few differences, even though they can make the same kinds of decisions in a lot of the same subject areas. The first thing you're going to want to think about is how many rules do you have to follow and how hard is it to understand those rules? A lot of people find that provincial court has less rules and the rules are way easier to understand, whereas you go to Supreme Court, you get something called the Supreme Court Family Rules. They're quite long and more complex. Again, we will be covering this in depth throughout this course, so hopefully that will make it less hard to understand these rules. Provincial court is less formal and generally more flexible. Supreme Court is more formal. You'll generally see people going around in suits. It's a little less flexible, so, with time and rules and things like that. Provincial Court generally has less paperwork and the forms are a bit shorter. Supreme Court, the forms are a bit longer. You might end up with more paperwork. And Provincial Court, you'll see a lot of people who are self-represented litigants. In Supreme Court, you generally tend to see a lot of lawyers, but you'll still see self-represented litigants, and it's still possible to self-represent successfully in Supreme Court. Provincial Court has a lot of locations across the province. Supreme Court does not have as many. One of the biggest differences between these two courts is filing fees. If you're going to Provincial Court, any kind of application you make or any kind of document you give to the court, they will not charge you a fee to submit. So that's all free. In Supreme Court, there are filing fees. So for example, if you're going to do a divorce in Supreme Court, it can cost you about $300 to submit the paperwork. There are ways to go around this, like you can get your fees waived. So it can be free in some circumstances. We'll talk about that later in the course, but it is possible to go to Supreme Court for free. Other thing in provincial court, though, is that they cannot award costs. They can only award expenses. So if you go to Supreme Court, they can award costs and expenses. Costs is what it costed for somebody to go to court for an X amount of days. So lawyers' fees, for example, for court for 5 days. If you win your case, then the other party generally has to pay you those costs. Or the judge can also say, what you were doing is really unreasonable. You're being kind of a jerk, and I'm going to punish you by making you pay a certain amount of money to the other side. So that could happen in Supreme Court. It will not happen in provincial court. They don't make those kinds of decisions. And then another big thing to remember about provincial versus Supreme Court is that provincial court only makes orders under our provincial law, and that's called the Family Law Act. Rachel will talk about this later, but that's why the provincial court does not do divorces. They only can make decisions under the Family Law Act. Supreme Court is allowed to make decisions under the Divorce Act, which is the Canadian federal law about divorce and separation. And that's why they're able to give divorces and this provincial court's not. And then, as I was mentioning earlier, if you're looking for a protection order or if you're looking for an order about a priority parenting matter, you might want to go to provincial court instead of Supreme Court because they have like a streamlined, simple process for that. It's free and it's faster than Supreme Court. Otherwise, you're kind of looking at, how much do I want to pay? How much paperwork is there? And things like that. So yeah, that is the difference between the two courts that generally see family law in BC. Now I'm going to hand it over to Rachel.
So So in BC, we have a couple different statutes or legislation that govern our law and where it comes from. So we can go to the next slide. So the Family Law Act, which is basically a form of law that provides the court with the authority to make rules or regulations. So in BC, we have our Provincial Family Law Act, and that only applies to the province of BC. So other provinces in Canada may have their own type of Family Law Act, but here in BC, we have ours is the Family Law Act. And it sets out basically defining terms. It helps the court to interpret the law, and it sets out the specific relationship between the parties. It applies to whether or not they're married or common law, their children, as well as professional legal representatives such as lawyers and like parenting coordinators and mediation, those kind of things. So the power that the court is given to enforce the rules from our Family Law Act, it helps protect people at risk of family violence. It helps to protect property that is involved in the family law matter. And it enforces court orders or agreements that have been made between the parties, either, as a cohabitation agreement or a separation agreement. And then it helps to manage the court processes as well. So if you have any kind of steps that need to be taken, it kind of governs how those steps be taken in a court. So next slide. So the Family Law Act tries to change how people solve their family law problems. So it tries to encourage people to find the solutions outside of family law court. So that would be something like Jennifer mentioned earlier with, settlement, any kind of dispute resolution. It helps make financial disclosure mandatory. So even when people are dealing with family problems outside of court, the Family Law Act governs that people need to disclose their financial information between the parties. And it also makes family law agreements more difficult to change. So as long as they were fairly negotiated between the parties, the terms were, brought together between them, they negotiated and worked on making an agreement together, then it helps protect those people and make it so those agreements aren't able to be turned over as easily. And it also promotes the use of parenting coordinators. So this is when there's a final agreement, when there's parents that have issues with parenting children, they can't really agree, a parenting coordinator can be used. It also helps with getting a final agreement in terms of care of the children. So Emily mentioned a little bit about the provincial and the Supreme Court, and the Family Law Act can hear claims, the provincial and Supreme Court can hear claims under the Family Law Act. So not all of the statutes or the laws in BC can be heard under both of the courts, but the provincial court and Supreme can hear both of the Family Law Act claims. Next slide. Okay, so the next one we have is the Supreme Court Family Rules. So this is another BC statute. So this is the rules in which the court applies the law, basically. And it only applies to the BC court cases, Supreme Court cases. So the BC Supreme Family Rules do not apply to any provincial court. The provincial court has their own family rules. So the Supreme Court Family Rules set out the regulations or rules on how a case will be conducted during the course of the litigation. And it also sets out the rules, information, and the steps needed for the forms and what court cases and different claims can be made. It also sets out the deadlines and scheduling information. So if you need a certain timeline for which you are able to do a response, or if there's a deadline that needs to be in place in terms of financial disclosure, that's where we're going to find the information in the Supreme Court Family Rules. The Divorce Act is a federal legislation, so that means that it applies to all of the provinces across Canada. So it's not different in each province. All BC, Alberta, all of the provinces use the Divorce Act. The Divorce Act is the law that deals with the breakdown of marriage in Canada. So it only applies to people who are married or who used to be married to each other. So this does not apply to parties that are common law. It's only when they are legally married to each other. So it will help basically set out the rules and talks about how parties that are married and how they are going to get divorced. When divorce orders from another country are recognized, if they get married somewhere else, and how the BC or Canada recognizes those marriages and the dissolution of those marriages. It also talks about the care and parenting of children after separation, child support, and spousal support. And the Supreme Court of BC only has the jurisdiction to hear matters under the Divorce Act as well. So the provincial court cannot hear any claims made under the Divorce Act. So a couple other guides that we have. So there's the main ones that we just talked about. Those are the kind of the main governing rules and acts that we use. The Federal Child Support Guidelines. Basically, it sets out how much child support someone is going to be paying for their children. And so that's going to depend where the parents, which parent or where the children or child live, how many children of the relationship there are to be supported, how much the pair makes each year, and that's used to calculate the supported child or children. And the guidelines establish a fair and standard support for children to help reduce conflict between the parties. So this one is just briefly touched on. This is not something that we'll really go over. We'll briefly touch on it in one of our next sessions. But the Child, Family, and Community Services Act, it provides the rules, the legislation that interprets and administers the safety and well-being of children. So this gives the court the rules to set out how to keep children safe in family law. So this one I'm going to hand back over to Jennifer, and she's going to talk about the solutions outside of court.
Okay, so solutions outside of court. So basically today I'm just kind of give a bird's eye view. You're going to learn more about settling outside of court, like in more detail at around week 9. So today it's just to kind of show you some options of how to settle outside of court. And just kind of lay a little bit of a foundation for everybody. Okay. Did you know that approximately 95% of family law cases can be settled outside of court? This was something that I didn't know for a long time until I started working in family law, but it's true. So court hearings and trials should always be your last resort. There are options for coming to an agreement outside of court. Settlements can happen at any point in time throughout your litigation journey. You can settle when you first decide to separate. So that could be when you separate, if you go and have a consultation with a lawyer to figure out what your legal options are. You can decide at that point, okay, I want to settle outside of court and I want to enter into something called a separation agreement. Sometimes that doesn't work, unfortunately, but settlement is an option throughout the entire time, even literally right before a trial happens, which I have seen before. And that is if a trial has been set. So you can attempt to settle or negotiate as many times as you need throughout this journey. Just know, the more your case progresses, the way you settle on issues you want to settle on can change throughout your litigation journey. So depending on if you do wind up going to court and you get some court orders, like what we'll call interim orders or temporary orders, which you'll hear about throughout this course. So basically what happens is you do come to, if you do get a temporary order, you and the other party might just agree, okay, that order is fine. So if you do want to settle, then you might want to move on to the things that don't have orders quite yet. To help you prepare for settlement and to keep your goals focused on the end result, create an outline of what your priorities are for each case, such as, are you looking to get an order or an agreement on parenting time and responsibilities? So this is matters relating to children. Are you looking to get an order on financial support, which could be child support or spousal support? Are you looking to get orders to divide assets and debt? Any investments, selling properties, or any mortgages, credit cards, credit lines, anything like that. For all the above, what is recommended is to write out what your ideal order or agreement would look like. So whatever your focus is on your case, write it out. Write out what exactly you want, and then kind of figure out, okay, where can I wiggle on this? So an example is parenting time. So maybe your parenting time, your ideal parenting time is, I want to have full parenting time. I want to have the child 95% of the time. So what happens if you can't get that? So you kind of have to find some wiggle room for yourself. Okay, so maybe I can't do 95% of the time. Okay, maybe 60% of the time. So just find your wiggle room with any of your ideal orders. So there are different types of settlement. So I'll go through 4 of the more common ones. I do want to note that some of these do involve lawyers. So I'm just going to put them all out there because it's very important that you know what each one is. So there is your standard, which is negotiation. So negotiation can be just between you and your spouse. You can do this through an email, letters if you want, just outlining what exactly you're looking for. And then from there, the other party would look at what you're looking for and then say, okay, well, I agree to some of this, but I don't agree to, some of the other things. So you can do it that way. If the other party does have a lawyer, you can do the same thing. You can do it. It's usually better to do it in a letter format. That way it's a bit more presentable, but also it's easier to keep track of than just throwing it into an email. The other option, so with doing a negotiation, if you do come to an agreement, you can draft something called a separation agreement. So I'll just do a little bit of an explanation of separation agreement. So separation agreement is basically like a contract, and it goes over everything that you and your former spouse agree on, and then you sign it. Once you sign it, it becomes the final result of your case. For mediation, so there's mediation. So mediation is basically, it's you and your former spouse, and you're with a third party person, which is the mediator. If you do have a lawyer, or if your ex has a lawyer, they would be present with the mediation. So mediation, it'd be the third party person that is going to try to see if the two of you can come to an agreement. Sometimes you can come to an agreement on everything. Other times you might be able to come to an agreement on some things, which is still fine. If you come to an agreement on some of the things, they'll put something together called a minutes of settlement, or sometimes they'll help put some kind of agreement together. But don't quote me on that. Some of them will help with an agreement. Some of them will just do minutes of settlement. Another one is a 4-way meeting. So a 4-way meeting, this is if the both of you have a lawyer. So 4-way meetings are basically what it sounds like. It's you, the other, your former spouse, both lawyers come together. Sometimes it can be a conference call. Sometimes it can be on video. Sometimes it can actually be in a room together. That's only if everybody is comfortable with that. And from there, they just try to have an open discussion to see, is it possible to come to an agreement? Another way is collaborative law. So again, this is another one where you do need to have a lawyer. So collaborative law is both parties have a lawyer everybody enters into an agreement. It's called a participation agreement, I believe. Basically what that is that everybody agrees that you're not going to court. You're going to try to settle everything outside of court. If unfortunately you cannot come to an agreement, then that lawyer can no longer work with you. If you do decide to get another lawyer, you do have to go find another lawyer, or you can represent yourself. Another one is arbitration. So arbitration, it's an outside of court resolution, but it is kind of like a mini trial. So instead of being in a courtroom with a judge, you are with a third party person. Arbitration is a little bit more, I guess, personable. It's not like where a judge is sitting up high and then you're kind of, both you and the other party are kind of sitting like or on the ground. It can be done by video. It can be done in a boardroom. So with that one, and it can be a little bit expensive because you are paying somebody to basically be with you for however many days. Like, so, some trials can be 2 days, some trials can be 5 days. Arbitration is the same thing, but that would be decided at the start of the arbitration process. And then another type, it's sort of alternative dispute resolution or outside of court, is having a parenting coordinator. So it was touched on earlier. So for a parenting coordinator, they're basically hired again as a third party to just help two parents parent their child. So any type of disputes, and it can be on anything. It can be where the child's going to go to school, daycare, what kind of activities, communication, anything like that. A parenting coordinator would step in and help. When it comes to settlement, just remember, settling is never a sign of weakness. Be open-minded to any types of offers you receive from the other party or the opposing counsel. If you ever do receive what's called a proposal or settlement offer from your former spouse or from their lawyer, give it time. Don't just get it and then react right away. If you get it, take some time to digest it. And again, just don't ever accept anything that you're not comfortable with. That is a time where if you can afford a lawyer, to get some legal advice. Rachel will go over in a little bit about all the different types of affordable services that you can reach out to throughout your litigation process. Okay.
Hi, everyone. I'm just going to jump in here for 1 second. Just to remind everyone, only court can grant a divorce. You can't get a divorce outside of court. So there are some situations where you do have to go to court, but it's very, very small. As Jennifer was saying, 95% of cases settle, and 95% of issues can be settled. So yeah, I also want to say thank you everybody for your questions. We're just going to get to them at the end, so just hang in there and we'll answer them at the end during the Q&A. Otherwise, yeah, I'm gonna hand it over to Rachel for resources.
Okay, so there are a number of helpful resources out there. It can be a little bit hard to navigate and find all of them. The biggest one I can recommend is Amici Curie, the Friends of the Court, our services. So just actually next slide there, Emily. Perfect. So we at AC offer free services to all types of people. So that's regardless of your income level. We don't ask about income whatsoever. And we often hold workshops, like legal form workshops, where volunteer lawyers and paralegals help parties fill out court forms in a number of different areas of law. So we obviously work with family law. There's also Aboriginal law, human rights, and workplace law, as well as a bunch of other areas, and that can be found on our website. So this is just kind of some of the pictures, but if anybody needs some of the actual resource links, you can certainly feel free to email us, or you can definitely Google these services as well. So AC is always working on new ways to provide access to justice, access to legal services, just like this school. So definitely check out the Amishi Curry website. The Legal Aid BC, that is a nonprofit organization, and they're committed to helping British Columbians resolve their legal issues. So they provide free public legal information, advice, and representation to people with low incomes. So they specifically have a threshold that they require for parties with lower incomes. I believe that property is something that can't really be held by somebody if they need to get legal aid services, but they do have many like public guides, self-help guides that have steps 1, 2, and 3 to be able to walk you through court processes. They can be very helpful as well. Next slide. So the Law Society of BC, they have continually working on low-cost information and services. So they are working with lawyers to try to offer different ways for people to get access to justice. So they're allowing lawyers to offer and bundle legal services, and that's the ability to help like a self-represented litigant kind of in the background. The Innovative Sandbox is something new that the Law Society has been working on, and that is trying to help paralegals give more availability to assist with self-represented litigants or just on their own as well, help in a broader capacity. Next slide. So the National Self-Represented Litigants Project, that's like we mentioned at the beginning of our section, we've really tried to look at their project and try to tailor it to British Columbia, and that's their website, and their project is definitely something you can check out for self-represented parties. So the Justice Access Center, you're able to go and different areas that lawyers are able to kind of help out. There's a couple different locations that you can go to and different areas, but specifically for family law as well. And Click Law is it's like basically like the be-all end-all of information on like wiki, right? So this is also a free website, and there's a lot of different guides that are published by a couple different lawyers, and they provide some resources, they provide education, and some self-help guides as well. The Justice Education Society, they offer a couple different resources. They have a section on representing yourself, and again, they have some self-help guides through there that you can read through when you are working on your own, as well as Access Pro Bono. They have access to like a lawyer referral service. You can do I think it's a 30-minute free complimentary consultation with a lawyer. And they work with a couple different areas of law as well. The Rise Women's Legal Center, where are we here? The Legal Center, the Legal Law Center, TRU Community Legal Clinic. These are a couple other areas that offer different types of areas of law, specifically working in family law as well. The Government of Canada also has a couple different resources available on their website. There are sections about divorce, marriage, and information about the child support guidelines tables. The Government of BC, they have a website as well that offers a couple different information, so you can kind of go through the different areas on the government website. And then, of course, your local courthouse and courthouse library. You can go to the registry. Most of the staff there are extremely knowledgeable, and they will be more than happy to help a self-represented litigant. The courthouse library is another extremely helpful resource. a couple different Supreme Courts, and the libraries, you can go and get help from the librarian, and they can help you research case law. You know, there's computers there that are available to be used, as well as you know, printers and such as well. So that's the end of our presentation right now. We have gotten a couple different questions. Let's just see here. So definitely feel free to put in some of the questions that you have in the chat. If there's anything else that you wanted to ask, just go ahead and pop those questions in there, and then we'll kind of go through and try to answer them as best as we can. Just a reminder that it's all kind of general information, so please don't answer or ask any questions about your specific cases. We aren't able to give any legal advice, so just keep that in mind when submitting your questions.
Okay. I can answer. There's one where there was a couple that seemed to be almost similar. So it was about if you can use both courts. In short, yes. Yes, you can. However, it can make things confusing. And you don't want to do something that I will call double dipping, where you get for example, child support, where you go to provincial court for child support and then try to go to Supreme Court for child support as well. The two courts don't talk to each other. They are both separate buildings with separate files. So they never ever correspond with each other. So if you start something in one court and then move to the other court, they don't know about it. If they find out, then it can make things a little bit trickier. So it's best to, if possible, it is best to avoid trying to jump from one court to the other. If you do, and some people have gone through that, where they've started off in one court and they're like, actually, it kind of needs to be moved. So if they started provincial, they're like, kind of needs to be moved to Supreme Court. So there is a way to move it from one court to another. It is a bit of a procedure. You can do it if the other party can agree to it. It does make it a lot easier. You can get a court order to move it from what they call venues. So from one venue to the other. So if your whole case is in Supreme Court and there's no divorce and there's no assets, you can move it from Supreme to provincial. It does have to be done by a court order. So if you and the other party can agree to it, it does make it a lot easier. Provincial court is the same thing. So if you start something in provincial court and you're like, oh, actually, this needs to be moved to Supreme Court, it's the same thing. You can do it by agreement. And then what would happen is you would fill out, and Emily or Rachel, if I'm making this up, please let me know. It is a type of application that you do. I think it's an application for a case management order. And that's where you would ask for your, to move the venues from provincial to Supreme. I did see a question there about if you have a divorce, but you start in provincial court, you can, as long as you keep them separate. So if you've started all of your, parenting, spousal, child support, if you started that provincial court, but you still need to get a divorce order, you can start a case in Supreme Court. You can technically do them at the same time, but you can run into the issue of, what if the other party is like, oh, you're going to jump into Supreme Court. Now I want to deal with all the matters in the Supreme Court. So from my perspective, I like to keep things organized and, as clean as they can be. So it's better to try to wrap everything up in provincial court, tie it up in a little bow, get orders if you can, and then start your divorce case in Supreme. So that's when you would file your notice of family claim and then do what's called an application for divorce. And then Emily, Rachel, is there anything else I'm missing, or have I touched on anything else? Or need to touch on anything else?
No,
We're good?
good.
Okay.
Yeah, I'd say that's mostly it. Yeah.
I
So
saw a question about how to basically how to get a judge to like you. So that might be touched more throughout the throughout this course. It might be more around week 7 or 8 about week 10, preparing for trial and hearings. So it's not about having the judge like you, it's just about how you're presenting yourself in court, how you're presenting your evidence, how organized you are, and how honest you are. But I won't touch on that too much because we will go into more detail later on about how to properly prepare, how to present yourself in court, the court structure, like the hearing structure, how to put your evidence together. It's just basically the foundation would be just to make sure you're being honest. You're not purposely hiding anything. You're not trying to be combative with the judge. Talking slow, talking in a calm tone, and not trying to, sometimes the other party, they might do things to trigger you. They might say things to trigger you. If they don't have a lawyer, sometimes lawyers are good at being what I would call the net, or like kind of the wall to kind of block some of the mean words that the other party is trying to say. But if you find the other party is purposely trying to get under your skin in court, it's best to not feed into that when you start kind of getting snarky, making rude comments about the other party, just being combative in general, judges don't like that. So it's just trying to maintain composure, just be calm, just stick to your notes, stick to your story, and just make sure you're being honest and truthful in that process. Okay. Oh, we got a lot of questions coming in.
I also just wanted to add on to Jennifer's response there. Just a reminder, like, judges, the best thing they can be for you is neutral when they're making their decision. They're not allowed, and it's not part of their job description, to like you or favor you over the other person. It's their job to make a decision based on the facts of the case. So the best thing you can have is a neutral judge that is just taking the facts as they are and making that decision. Then on the other side, the worst thing you can have is a judge that really doesn't like you. So really the question should be more like, how do I make sure a judge doesn't dislike me? So you want to just make sure that you're not doing anything to make them dislike you, as opposed to trying to do something to make them like you, if that makes sense.
Okay. Maybe we should take a 10-minute break. I do see a lot of chatter in here, so I want to make sure that because we did go through our materials quite quickly. So I do want to make sure that we can answer most of the questions in here. So how about we take a 10-minute break? That way we can make sure we gather all the questions that everyone's been asking. Does that sound good?
So we'll see everybody back here at 6:45. How's that?
Perfect. Yeah. Okay. All right.
Hi, everyone, and welcome back. I'm just going to give everybody a few seconds here to join back on the call if they're not here already, and then we'll get back to questions.
Shall I get started? All right, so I saw someone here comment about the website forms, about them not being current or easy to download. Unfortunately, you are correct. They are definitely not easy to download because the Supreme Court changed the rules recently, and they've changed a lot of their forms. There's no longer open resources to our knowledge that have the word workable documents. So unfortunately, it is going to the BC Supreme Court website and using their PDF versions. So I know I have ran into it with a lot of clients where they have troubles accessing the documents. So on the BC Supreme Court website, when you click on their forms, there's a forms fillable PDF. What you do is when you click on it, you do have to click the download button and it goes to your download folder on your computer. You have to open up that download folder, click on it, and then it opens up. Those documents, unfortunately, they're not the easiest to edit or use. Through AC, if any of you are Amici Curie clients, we do our best to use only Word documents because we do have resources and templates for that. So those ones are a little bit easier to format in a Word version. I don't know if the Justice Access Center, they are a really good resource as well for getting help with filling out documents. Same with the library. If you go to the Supreme Court library, you can ask the librarians to help you access the documents. And they're usually pretty good at like sitting there with you, showing you where to go, how to download them. And then if you need help editing, sometimes they can, if they do have availability, it depends on if they're busy or not. They do have availability to help you at least edit the documents a little bit. But unfortunately, however they've changed it, they don't allow the public to have Word version documents, which is very frustrating. I find it very frustrating.
Yeah. Oh, I was gonna say.
Go ahead.
Oh, I was gonna say, and I'm not sure if they, as far as I know, like I saw this a month ago or so, they do at some courthouses, if you go in person, if you go to the family registry, or if you go, to a Justice Access Center, or any of those other resources in a courthouse, you can ask them for a paper copy of those forms, and they usually come in like a booklet format. With instructions on how to complete them. And you can actually fill them in by hand if you want to do that as well. It might be a little harder because there might be too much information to put in there and you'd have to write like teeny tiny, but some of the courthouses still do that as far as I know. But do correct me if I'm wrong, Rachel or Jennifer.
We still offer that, yeah.
Yeah.
So there is a question about how to get financial disclosure. So some of these things can more so be discussed when we have one of the speakers talk about applications. I think that's going to be in week 7. So yeah, I think we'll kind of deal with some of the how-to ones in the court appearance one. Let's see, we have I think Emily was going to talk about the potential conflict with the Family Law Act and Divorce Act.
Yeah, and also like if you do notice that we aren't answering some of the questions in the chat, that is because they are bordering on legal advice, and we are not able to give legal advice during our sessions. So, but yeah, so the Family Law Act and the Divorce Act, do they ever conflict when making a legal basis for an application in Supreme Court? The answer is it depends, which is this is the most legal answer ever, but it depends. So the Family Law Act is a provincial law, and the Divorce Act is a Canadian federal law. In law, we love to have, you know, like hierarchy and like levels of things. So like as you see, like levels of court, for example. We do that with our laws as well. So if there's a provincial law, generally a federal law, so the Divorce Act, for example, will overrule anything that's inside the Family Law Act because it's a provincial law. So for example, the Family Law Act and the Divorce Act both have parts that talk about the rules for spousal support. If you get a spousal support order under the Divorce Act, you can't go back and apply for one under the Family Law Act because the Divorce Act is kind of the more powerful law. You already have the most powerful tool. You know, you have an order under the most powerful tool. Now, if you have it the other way, like for example, if you have the Family Law Act and you get spousal support under the Family Law Act, you can still go back to court in Supreme Court and say, I'd like spousal support under the Divorce Act. So because the Divorce Act is more powerful than the Family Law Act in some ways, that's only if they have laws on the exact same thing. If you ever have the chance to go take a look at the Family Law Act or the Divorce Act, just very quickly, don't do too much reading into it because it gets kind of weird and confusing and long. You'll actually notice that the Family Law Act is really, really, really long. And the Divorce Act is actually just like a few pages. It's not that long at all. And you'll notice that because the Family Law Act actually has a lot more detail in it about how to do certain things in BC. And it also deals with a few things that the Divorce Act doesn't actually deal with. Just like divorce is only in the Divorce Act and not in the Family Law Act. So it really depends on what you're looking for. But if they do overlap, generally the Divorce Act is going to be, you know, the rule as long as you are married or have been married to the other person who you're in court with. Otherwise, if you've never been married, you'll never have to think about the Divorce Act. You'll go straight to the Family Law Act, and that will be your law. So it really does depend. And that's kind of my answer. Sorry, I wish I could be more yes, no, but it really depends.
And I just quickly saw a question just about the form from moving to provincial to Supreme Court. So I can tell you that right now. It is called the Application for Case Management Order. It's Form 10. So if you go onto the provincial court website, you just scroll down. It's all in alphabetical order when you click on provincial court forms. So you're looking for Application for Case Management Order Form 10. That document has all the instructions of what you can use that document for, and one of them is to transfer files from one registry to another. So that is the document that you would use if you're trying to transfer out of provincial court into Supreme Court. And okay. And then another question, if you settle your case and you need to obtain a divorce, or you need the judge to declare your divorce, yes, you do. So if you settle your case, so you settle outside of court, you get a separation agreement, you do need to apply to court to get that divorce. There is no way around it, unfortunately. And then another question. So would you like to clarify that if you have a separation agreement that is agreed upon and signed, what happens to it? Does it get filed somewhere? So if you have a separation agreement and it's filed and it's signed, or what they call executed, so it really depends. Some people, they feel they don't need to file it because it's more of an optional step, but you can file it. So you can file it in court. I would have to look up the exact form you need, but you would you would file it with a specific form and then it would sit in a court file. If you have a separation agreement and you were married, it's best to just go ahead and get that divorce order. You don't necessarily, if you have a separation agreement and you don't bother with the divorce process or just getting that divorce order, you don't have to, but down the road, if you wish to remarry, you do have to get a divorce. So you cannot get remarried if you're still legally married. So legally married is, you've got the marriage certificate. Legally divorced is you have a final order that says, as of this date, you are divorced. And it's signed by a judge and it has a court stamp on it. So if you do have a separation agreement, personally, I would just go ahead and just apply for that divorce just to, cut it.
Yeah. And if you do decide to file the separation agreement in court, so an agreement, if somebody doesn't follow the agreement, if you haven't filed it, there's nothing you can really do legally about somebody else not following the agreement. But once you file it, it actually becomes kind of like a court order. So the court can help you make sure the other person follows the agreement. So that's also one thing that that happens when you file it.
And then somebody asked about having met with duty counsel and using duty counsel a few times and want to know if they can qualify for legal aid. So yes, even though you've met with duty counsel, if you still want to apply for legal aid, you're more than welcome. There's nothing stopping you from applying to legal aid. Even though they're under the same umbrella, they're two little entities and they don't talk to each other too much. So basically with legal aid, the whole thing around legal aid is if you qualify financially and what your issues are. Legal aid can be very specific of what they will provide a contract to, is what they call it. So they always issue a contract and it's based on, so they have something called limited scope. So limited scope contracts mean that they're only going to help you for, you get a contract for a lawyer to only help you for a very specific thing. And it doesn't technically fall under their typical family law case. So under legal aid, a typical family law case is normally has to do with children. Children, family violence, what's called child abduction. So child abduction is if one parent removes a child from a country outside of Canada, sometimes even outside of a different province, and they bring them to BC. You can qualify for legal aid. Legal aid also looks at, what your financial situation looks like. So if you don't fall under that typical regime of you're dealing with parenting matters, you're dealing with family violence, or you're dealing with an international child abduction or a child abduction, you could go under something called limited scope. So limited scope would be, it could deal with what's called unbundled services. So legal aid would cover where you would represent yourself, but legal aid would give you funding to have a lawyer help you in the background. So that lawyer would give you legal advice. They would help you draft any documents that you need and help you get ready for that next step. So that is a version of limited scope. Sometimes, depending on your situation, sometimes they'll help you for other things. I have seen it where they have given a contract to somebody who is not dealing with anything related to children. There was some family violence involved, but there was an issue with spousal support, trying to get spousal support, trying to deal with property. So they did give a contract for that. So sometimes you can get a limited scope type of contract, but you can qualify, you can apply for legal aid even if you do use other resources. Let's see.
Oh, Sorry, I think we also got a question earlier on about what is duty counsel. So just to clarify, if you haven't heard the term duty counsel before, it is somebody, a lawyer who is in the courthouse and they provide free legal advice to people without lawyers. So if you go into the courthouse, you go up to the registry or any of the staff really, and you say, I am self-represented and I would like to see family duty counsel, they will usually point you in the right direction and set you up with whoever's at the courthouse on duty that day.
Okay, let's see. No, what session? So family maintenance, I believe that will be next week. So next week's session will be communication pointers and matters relating to children, which will touch on child support. And usually child support and family maintenance can go hand in hand. So I believe it will be touched on in that session.
There's a question.
Yeah, some of these questions. Oh, go ahead, Rachel.
There's a question about a post-nup agreement. I'm not sure if Emily kind of touched on that, but if it's signed by both parties, do I need to file it? So essentially, like Emily said, that if the agreement isn't filed with the court, it can't be enforced. So if you have a post-nup agreement and it needs to be enforced at some point, then it definitely should be filed with the court. So if it needs to be enforced at a later date, you can go ahead and use the court to do that. Questions about contempt. I mean, something such as that, it really depends on the actual specific orders that are not being followed.
I don't know if it's okay to jump in, Rachel, but from what I know about contempt orders is, this is just off the top of my head. It is a very high threshold. If you're trying to get some kind of order to show the other party has not been listening to their court order. And there is a system you do have to use. Not too many people do contempt orders. It has to be very, very serious so that in order to get a judge to give you an order for contempt, it is going up in front of a judge, filing a notice of application and showing all the ways that somebody was purposely avoiding orders and why it is negatively affecting you. So it is from my understanding, it's a very high threshold to get such an order.
Yeah, and like just to add on to that, if somebody is not following an order or they're not following an agreement, there are usually things that you can go about doing to make sure that the agreement is enforced or the order is enforced before you get to that kind of last stage of making a contempt application. So for example, if somebody's not dropping off your child at the time that's supposed to be, they're supposed to be dropped off in the order, or somebody's, withholding your child from you, you can go to court and make an application to have the order enforced. So that will essentially force the other person to do what they're supposed to. Whereas the contempt is more like you're punishing them for not doing what they're supposed to. So the court generally goes more for the forcing people to do what they're supposed to do versus punishing them for not doing things route. So yeah, just to add on to what Jennifer was saying.
Thank you, Emily. Okay. And I do see a lot of chatter about legal aid and legal aid lawyers. So with legal aid lawyers, it's just like meeting a privately paid lawyer. Sometimes you get some really good ones. Sometimes you get some not so good ones. The thing with legal aid and legal aid contracts is the lawyers are only given a certain amount of what they call hours. So what you see as a contract, the lawyer sees as hours. They have to stick to a certain amount of hours. And if they get used up, it's really hard for the lawyer to obtain what's called extended hours. The lawyers have to prove why it's absolutely necessary. So there are some lawyers that will really just stick to whatever contract they've been given. And when I say whatever contract they've been given, is legal aid will give them a contract with what issues they have to deal with or they're supposed to be dealing with. And some of the lawyers will stick to that. And again, I don't want to paint all lawyers with the same brush, especially when you're assisting with a legal aid contract. But just like a privately paid lawyer, you have some really good ones and you have some really bad ones. But I do understand. I understand from a client point of view, it is very frustrating, trying to find a legal aid lawyer. It can be frustrating, dealing with a legal aid lawyer. And I know on the other side, dealing with legal aid can be also very frustrating as well. Unfortunately, with some with legal aid lawyers, they're very restricted based on the contract they have and the amount of hours that they're given. Okay, any other questions? So I think we've touched on a lot of questions. If you have questions that pop up during the week, questions about this session tonight, feel free to send an email. So that was the email address that we had at the beginning of the slide, info@litigantschoolbc.com. You can send your questions there during the week and one of us will respond back to you. We'll try to answer your questions the best that we can. So each week you will get a copy of the PowerPoint presentation as well as the recording of this session. So for anybody who, if you can't make it to a certain week, and I know that some people can't always commit to every single Tuesday, you will get a recording of that session. For any of you who are going to be, if you're running late or you have a last minute emergency, you can no longer attend, just try to send an email as soon as you can. Because what we will be doing at the start of each session is we're going to try to wait for as many people as possible before we start the session for that night. So if you find yourself running late or last minute you can't come, just send an email to info@litigantschoolbc.com. Just to say, hey, I'm running late, or I'm sorry, I can't attend tonight. I had something come up, and you don't have to tell us what it is. You can just say, I can't attend tonight. That way we know, and then that way we can start right at 5:30 or as close to 5:30 as possible. Yeah. So for next week, so it'll be 5:30 again. So next week we will be touching on communication pointers and matters relating to children. So communication pointers are basically, how to, as nicely and as calmly as possible, communicate with the other party. Some pointers, some tips and tricks to, to something to keep in your toolbox or in the back of your mind. And same with communicating with an opposing counsel. It will touch on matters relating to children. So parenting time, parenting responsibility, child support, and understanding some of the services you can access for your children. One of the main ones is Child and Youth Legal Center. It is a nonprofit society, and they do help children who are in the middle of a family law dispute. Okay. Emily or Rachel, anything else to add?
No, I think that's all the questions that we have in the chat right now. Yeah, if there's any other questions, like Jennifer said, just send them and send us an email. And just like Emily mentioned in the chat, just a quick reminder, we will be sending out the link again before each session. So probably Monday evenings, you'll get the link. It is the same link. You know, if you want to keep it somewhere, you can save it and use that same link again for the next session. But we'll send out a reminder with the link again right before the session.
Okay. Well, thank you everybody for taking the time to attend tonight. As we mentioned, this is the very first session of its kind and the very first program of its kind. So we appreciate all of your patience, you know, as we learn our way through this experience together. And we'll see you next week.
Hey guys, thank you.
All right. Have a good night, everybody.